Hello everyone, hope you have an amazing day and welcome to my new blog. So today our topic is the Contract Labor Regulation and Abolition Act 1970. This legislation regulates the employment of contract laborer in establishment and by contractor. The rules for implementing the provisions of the act vary from state to state. So applicability of the act, first of all we discuss about this. An establishment which engages 20 or more person or engage or any day of the preceding 12 months as contract laborer come under the preview of the registrations. So the legislation is also applicable to contractors who employ workmen as contract laborer in his or her organizations or who employed on any day of the preceding 12 months. Now authority under the act. So the registering officer of the area, the registering officer of the area is person to whom application shall be made for the grant for certification of the registrations. So for the purpose of engaging contract laborer, any change in the establishment shall be intimated to the registering officer within 30 days of changes, and an amendment to the certificate shall be made by applying to him. So the licensing officer of the area officer is person from whom a contractor shall obtain license for the purpose of engaging contractor. He is entitled to make such investigation as registered in respect of the application reviewed from a contractor. Section 12. Inspector. Under Section 28, inspector shall be appointed for a particular area of the local limits for which shall be defined. He has the power to enter at all responsible hours any place where contract labor take place for the purpose of varying or verifying register records or notices, to examine person, to collect information, to seize or to take copies of register records of wages or notices, and to exercise such other power as is prescribed. Now important definitions. Contractor with relation to an establishment. A contractor is a person who undertakes to do some work for the establishment through contract labor. So not being a mere supply of good or articles of manufacture to the establishments, or any who supplies contract labor for any work of the establishment and includes a subcontractor also. Now principal employer in a factory is the owner or occupier of the factory, and where a person has been named as the manager of the factories under the Factory Act 1948. Such person is the principal employer. Always remember that. In any other establishment, any other person responsible for the supervision and control the establishment. Workman means any person employed in or in any connection with the work of any establishment to do any skilled, semi-skilled or unskilled manual, supervisory, technical and clerical work for hire or reward, whether the terms of employment be impressed or implied, but does not include any person who is employed mainly in a managerial or administrative capacity, who being employed in a supervisory capacity draws wages exceeding 500 per month, or exercise either by virtue of powers of vested on him, or by the nature of the duties attached to the office's functions, which are of managerial nature or 3. Who is outworkers to whom any articles managerial are given out by or on behalf of the principal employer for being proceed. Now, important provisions of the Contract Labor Act 1971. Register of principal employer. The principal employer has to file an application for registration to the registering officer. The application must be made in triplicate, accompanied by treasury receipt showing the payment of fees. The registering officer will register the company and issue a certificate of registrations. If the company fails to obtain certificate of registrations, the position would be that the workman employed by the contractor would be deemed to be employed by the company which is the principal employer. Now, licensing of contractors. The principal employer should engage workmen only through licensed contractors. The principal employer should therefore ensure that the contractor engaged by it for various services hold a license issued under the Act. Responsibility for payment of wages. The principal employer must nominate a representative to be present at the time of disbursement of wages by the contractor, and such representative must certify the amounts paid as wages to the contract laborer. Facilities to the provided to contract laborer. So the following facilities should be provided to the contract laborer if the contractors do not provide it. Number 1, restroom. Number 2, canteen. Number 3, latrines and urinals. Number 4, drinking water. Number 5, fast and facilities. So, submission of returns. The principal employer should file a return within 15 days of the commencement or completions of each contract work under each contractor. The principal employer has to file annual return in duplicate to this registering officer before the 15th of the February every year, containing details of the contracts engaged in the previous year. So the contractor should file half-yearly returns in duplicate within 30 days from the close of the half year, which in the case is a period of 6 months commencing from the 1st of January and the 1st of July every year, to the licensing officer. Now, maintenance of records. The principal employer should maintain a register of contractors. The contractors should maintain the following registers. Number 1, register of person employed. Number 2, master rolls. Number 3, register of wages. Number 4, register of deductions for damage or losses. Number 5, register of fines. Number 6, register of advance. Number 7, register of overtime. Now, displays. Notice showing the place and time, the disbursement of the wages, rates of wages, hours of work, wage period, dates and payment of wages, name of the addresses of the inspectors having jurisdictions, and date of payment of unpaid wages should be displayed in the premises in the local language understood by majority of the contract labor. Now, Maternity Benefits Act 1961. Motherhood is a very special experience in a woman's life. A woman needs to be able to give quality time to her child without having to worry about whether she will lose his job or source of income. That is where the concept of maternity leave and the benefits it entails comes in handy. The Maternity Benefits Act 1961 gives her the assurance that her rights will be looked after while she is at home to care for her child. That means, I mean to say, newborn child. And the objective of the act is to be regulate the employment of women in certain establishments for certain periods before and after childbirth, and to provide for maternity benefits and certain other benefits also. So applicability of the act. This act applies to women who work in factories, mines, plantation, circus, industry, shops and establishment with more than 10 employees. It does not apply to employees covered by the Employers State Insurance Act 1948. It can be extended to other establishments by the state governments. Now, important definitions under this act. Child includes a stillborn child, Section 3b. Delivery means the birth of a child, Section 3c. Employer means in relation to an establishment which is under the control of the government, a person of or authority appointed by the government for the supervisions and control of employees, or where no person or authority is so appointed to head the departments. In relations to an establishment under any local authority, the person appointed by such authority for the provisions and control of employees, or where no person is so appointed, the chief executive officers of the local authority. In any other case, the person who or the authority which has the ultimate control over the affairs of the establishments, and where the said affair are entrusted to any other person, whether the called a manager, managing direction, managing agent, or by any other name, such person, Section 3d. Now, establishment means a factory, a mine, a plantation, a establishments wherein persons are employed for the exhibitions of aerobatics, other performance. A shops or establishments, or an establishments to which the provisions of the Act have been declared under subsections 1 or section 2, the applicable section 3e. Now, miscarriage means the expulsion of the contents of the pregnant at any period prior to or during the 26 weeks of pregnancy does not include any miscarriage, the cause of which is punishable under the Indian Penal Code 1860 section 3J. So wages means remuneration paid or payable in cash to a woman, and includes dearness allowances or house rent allowances, incentives, bonuses, and the money value of the concessional supply of the food, grains, and other articles. It does include any other kinds of bonuses, overtime, earning, any contribution toward the pension funds or provident funds, and or any gratuity payable on the termination of services, section 3n. Now, person entitled to maternity benefit. Every woman is entitled to the payment of maternity benefit at the rate of the average daily wages for his period, her period of her actual absence immediately preceding the including the day of her delivery, and the 6 weeks immediately following the day. The average daily wages is calculated on the basis of the amount payable to her the day on which she has worked during the period of 3 calendar months immediately preceding the date from which she has absent herself on account of maternity, or 1 rupee a day. whichever is higher. To be eligible for maternity benefit, a woman should have worked in an establishment for not less than 160 days in the 12 months immediately prior to the date of her expected delivery. The maximum period for which any woman can be entitled to maternity benefit is 12 weeks. They include 6 weeks up to and including the day of her delivery and 6 weeks immediately following that day. If a woman dies during his period, the maternity benefit will be payable only for the days up to and including the day of her death. So, however, if she delivers a child and dies during the delivery or during the period of 6 weeks following the delivery, the employer will be liable for the maternity benefits of the entire period of 6 weeks immediately following the day of her delivery. If the child dies during the period, the liability will be only up to and including the day of the death of the child. In case of the woman dies before the receiving benefit, the amount must be paid to her nominee or legal representatives. So, in the event of a miscarriage, a woman must produce relevant proof that she has suffered a miscarriage. This will entitle her to receive leave with wages at the rate of the maternity benefits for a period of 6 weeks immediately following the date of the miscarriage. Women who are ill on account of pregnancy, delivery, premature birth of a child, or a miscarriage are also entitled to a notice of the absence of the leave with wages at the rate of the maternity benefit for a maximum period of 1 month. However, they must submit proof of their illness. So that's for the video, my friends. In the next blog or in the next episode, I will discuss about the notice of claim for maternity benefits. So thanks a lot for watching my videos. If you like my videos, please subscribe, comments, share my blogs. Thanks a lot.